Eric Segall and Lori Ringhand with us today, and they're both professors of law, written books and all kinds of stuff. You have those bios in your program, so I'm not going to go into that, but I'm going to kind of turn it over to them. I'd love for them to give their responses to the play from their perspective, and then we'll just open up the discussion and questions as well. So,
thank you.
Go for it.
Thanks for staying. Thanks for having us. I'm not sure we can top that. What an unbelievable performance that was. We both read the play beforehand, but we were struck by just how powerful that was. I'm Eric. This is Lori. We have about 40 years of teaching between us or something. I had the majority of that. So we are actually. So I'm kind of an all-purpose con law professor, but we are really fortunate, and I'm also married to Lynn Segall, who's somewhere here, who's on the board of this theater, which is one of the reasons we're here.
We have another board member here, Margie, also.
Lori happens to be, I'm not just saying this, one of the leading experts, if not the leading expert, in the United States on judicial nominations. She, in fact, wrote the book. And to my chagrin, or co-authored the book, excuse me, and to my chagrin, I have argued with her in the past and always lost on confirmation debates. I win every other debate, but I lose the confirmation debates. So what we thought we would do is I would let Lori talk for a couple of minutes and give her impressions of the play and the significance of the Judge Bork hearings and how they're playing out. I may add a couple minutes to that when she's done, but it's not going to be long. And then we really just want to have an informal discussion. And I know we have lawyers and non-lawyers in the group. We have all kinds of people from diverse backgrounds. And I've kind of made a career of suggesting that smart, diverse people can talk about the Supreme Court as well as lawyers can talk about it. So we'll get to all that, but first, here's the play.
Thank you. That's very kind of you, Eric. And thank you for inviting us to join you here. The play was wonderful, and it was really a treat to see it performed as opposed to reading it. It's so dynamic, and the actors were just wonderful. Particularly, I have to say, the senator from Kentucky. I began my academic career at the University of Kentucky and spent 7 years in Lexington, Kentucky, and they absolutely nailed it. So that was wonderful. So thank you so much for sharing.
Little did we know.
With us, they're fantastic. And the bourbon, you had to have the bourbon. But as Eric said, I've done a lot of work with the Supreme Court confirmation process. And in particular, what my co-author and I did, we were talking the way at an academic conference, kind of hashing over the work of in our area about the Supreme Court, and realized that we shared the same pet peeve. And that pet peeve was that there is an awful lot of opinions and theories about what happens at the Supreme Court confirmation hearings, particularly the hearings where the nominee testifies before the Senate Judiciary Committee. There's a lot of theories, a lot of ideas, and we realized that we were both very irritated by the fact that there is very little actual concrete specific data or information about what really actually in fact happens at those hearings, instead of what we all kind of collectively remember we think happened. So what we did, and I'd highly recommend this because it's actually really fun, we went back and we read the transcripts of every Judiciary Committee hearing at which a Supreme Court nominee testified in an open transcribed session and took general questions. And that took us back to 1939 and Felix Frankfurter. So we read all the way from 1939 and Felix Frankfurter to the Alana Kagan hearings. And they kept getting longer and longer and longer. So the project was fascinating because what you see when you undertake a project like that, when you actually read, and we did a lot of coding, we gathered information about what the senators were asking about, what the nominees were answering, how responsive they were, what the main issues of the day were, etc. And what you realize when you go through that experience is you really do see the history of that period of America, from pre-World War II up to our current day. You see the entire history of the country unfolding in those transcripts. Because and I know Eric and I agree about this, we don't agree about a lot, but we do agree about this. The Supreme Court and the confirmation hearings reflect what people care about in America today. as de Tocqueville said, in America, political issues become legal issues. And that's because of the thing that I think is the beauty and in some ways the curse of our Constitution. Our Constitution is very important. It is our founding document, and it's very, in many places, opaque. And it's
Step missing. I agree with that description. It was one step missing. I would say that might be a good system. I'm not even criticizing that system, but they should be honest about it. That's what drives me crazy. If you read Supreme Court opinions, you'll read text, history, and prior cases, and then they'll say, our reading of these text, history, and prior cases yields the conclusion X, Y, and Z, and a reasonably bright person with 2 years of legal study can say, no, it doesn't. You cannot get from those three premises.
or you can get
to
there,
that
but you don't get exclusively there.
Yeah, there are other reasonable conclusions that can be drawn. So what I want them to say is what Justice Kennedy once did in a case that many of you might remember, but people we teach today don't remember. In the 1980s and 90s, term limits was a huge thing. Should we allow the states to put term limits on members of Congress? Lori has a much better background in these kinds of issues than I do. I have no idea if it's good or bad. But Arkansas wanted to do it. And the question was, could they? And Justice Stevens, who I respect a lot, wrote a very long opinion saying they could do it for historical reasons. And he went back, and it's 35 pages of history. And Justice Thomas wrote a dissenting opinion for 4. It was 4-4. It was 5-4. And for the liberals, conservatives. And Thomas said, here's why history stops us from doing it. It was all bullshit. Excuse me. You cannot get there from history. You just can't. I've done it. You can't do it. What Justice Kennedy said is the swing vote, which he always is almost, the swing vote. He didn't talk about history at all. He didn't talk about prior cases. He didn't get into that. There's 40 pages on each side. He wrote a 12-page opinion or 15. He said, I think term limits are bad. Congress has to have its own identity. We can't let 50 different states define Congress' identity. Why? Because I think it's a bad rule. That's what I want. And then the American people could, and by the way, Justice O'Connor did that fairly often as well. I criticized her for that in a younger stage of my career, but now I see.
I remember that stage.
Yeah. but now I see that maybe she was on to something. I mean, they both do doctrine a little too much, but at least Kennedy in that term limits case and Justice O'Connor in some other cases admit what they're doing. I think term limits are bad. We're not going to have them. If they could.
Yeah, so I think our court judicial reasoning and judicial decision making exists on a spectrum, not a dichotomy, right? And our court is a common law court that argues from precedent, more or less, even though we talk about other things as well. But we don't start at ground zero with most constitutional texts. We're building on prior cases that have been decided in particular ways. And as a common law court, our justices give more reasons, certainly, than judges will in a lot of civil law countries, where you'll read decisions, and this is truly maddening to anyone trained in the American legal system. You'll read a decision out of France 20 years ago. This is less so now with what used to be the EU. You'll read these decisions where the high court judges will say things like, fact X, fact Y, here's the statute, therefore, and then say they're concluded. And it's crazy because you know that it just doesn't work. We do more reason giving than that.
But the false reasons.
Good justices, in my opinion, the most persuasive justices, will tell you why they think their bundle of reasons is a little bit better, a little bit more persuasive than the other guy's bundle of reasons. But, and this is another point of agreement between us, I think, we live in a constitutional culture. We as a country, our Constitution is a bit like the Queen in Britain, right? It is one of the ways we define ourselves. We define ourselves as constituted by this document. And that means that we look to it not just for day-to-day governance, we look to it for aspirations. We look at it to celebrate who we think we are and who we want to be. In that type of constitutional culture, it's just not very inspiring to say, yeah, the other guy's argument is okay, mine's just a little bit better, so let's go my way instead. So the reverence with which we hold our Constitution is part of the reason why we don't have the completely stripped down honesty that Eric thinks would be a better world.
Judge Posner has said that our Supreme Court is kind of like the House of Lords. To some degree, it used to be, and I think there's some truth to that. I also say that Justice Scalia's death we have a long time to see how that plays out. But I think the reverence with which we hold this court, some people hold this court, I think is going to, we might be at a crisis. We've had crises before with the Supreme Court, in 1936, some other times. We might be there. We'll see. Let's take this thing.
Because of the lack of a ninth justice right now, or something else?
So it's my political prediction, and that's worth about 10 cents, that if Hillary wins, let's assume that for the moment, because we have much bigger problems in the Supreme Court if that doesn't happen. If Hillary wins and the Senate stays Republican, I don't think they will confirm somebody for you. And if I'm right about that, I think I am. Now they'll do a political calculation. It'll depend on the red states and the blue states and how many senators. But I think there's a chance of that. They think they own Scalia's seat. There used to be seats at the Supreme Court: a Western seat, a Jewish seat. There's still an African American seat in theory. I think they own Scalia. I don't talk about them, but I think they own Scalia's seat, and that can spin out in a lot of ways. That could do a lot of damage to the Supreme Court's institution alone. It'll eventually come back, but we've had crises before in the Supreme Court, and normally the court comes back stronger after a period of time. We'll see.
That's an interesting point that I want to follow up on just real quickly. This notion that there are, you mentioned geography, there used to be a Western seat or an Eastern seat. And I think that's absolutely true. And one of the things that is clear when you go through kind of reading the history of the Supreme Court, we sometimes talk about the Supreme Court today as if these battles are new and different and more partisan, more political. They're not. They've always been up and down like this, right? It's not that every nomination and every seat is highly controversial, but there have always been controversial nominations interspersed with non-controversial nominations. And the controversies have always been political. What's changed, I think, is that a lot of this used to be satisfying different constituencies. National identities were largely formed by geography because of the narrowness of the electorate. As we expand the electorate, as more people, more Americans own our democracy, women and people of colors and people of color, people of different sexual orientations, as more and more people claim their identity and their place in our politic, of course, what the court and the Senate and the president have to respond to changes as well. So instead of caring about the Western seat, we're now satisfying different political constituencies. But the game is the same. You had a question?
I was just wondering what you thought, since you've read all these transcripts, about the tone. I know the politics, there's always been politics, but it seems like rules of decorum have gone by the wayside, especially in this political season. So my curiosity is about the tone of how they're questioned.
Yeah, it used to be really nasty. I want to say when it's the transcripts only started in 1939, so I'll start there. Felix Frankfurter's hearing. Felix Frankfurter was 8 years old when he immigrated to the United States. He did not speak English, and when he was nominated to the Supreme Court by FDR, the anti-communist crowd went at him. It was because he was Jewish, it was because he was an immigrant, it was because he was a New Dealer. They called him a traitor, they said he hated America, they pounded on the table, they brought people in to testify about how his race, by which they meant his Jewishness, disqualified him because he couldn't possibly be true to the Constitution. He would always be true to his foreign masters. And it was not decorous, it was riotous. And he was not planning to testify. And finally his advisors told him, the president's advisors told him, you have to go in there and say that you are not a communist and you love your country. So finally he did. This was the first nominee to testify in open court on an open question. They called people to testify on particular little issues before. But he had to go to testify to deny that, to kind of claim that, no, I don't actually hate America, it'll be okay. William Brennan had a very, very rough time in the 50s. Thurgood Marshall's hearing was horrifying.
They called him stupid. They called him stupid.
Strom Thurmond, who was on the Senate Judiciary Committee, went through through this recitation of what at the time would have been considered very abstract facts about the particular senators who sat on the committee that drafted the 14th Amendment. And he went through all of these, and you don't know the answer to that either. No, sir. And you don't know the answer to that either. No, sir. And it was painful and it was horrible. So the tone is not worse. It's televised, and that makes it longer, and it means we see the sound bites. But this was never a pretty process.
Thank you.
Somebody else. Let's have just over here this time. Go ahead.
Speak loud.
Okay, speak loud.
Following up on what you said about personal factors, how much does the Judiciary Committee question a nominee about their personal life? For instance, if I have a brother-in-law who was a criminal, would that disqualify me?
About 20% of the questions, this is data, about 20% of the questions that the senators ask, and this is aggregate over our 70-year data set, are about personal histories. And what that is changes from nominee to nominee, but that's about the same percent as are about judicial philosophy. And then there's a whole bunch of chatter that's about the administration of the hearing itself, and a lot of discussion of civil rights. Those are the main topics covered. It is interesting when you look at the nominations of our female justices and the justices who are people of color. Interestingly, they're actually asked slightly fewer questions about their personal narratives, even though when they talk about their personal narratives, they work very hard to kind of wrap themselves in the American story, right? You pull yourself up by the bootstraps. This is Clarence Thomas's story about coming from pinpoint.
Erin, I really love that you are so unbiased.
It's his narrative of coming from Pinpoint, Georgia, right? They tell a story. Felix Frankfurter, again, did the same thing as a Jewish nominee at a time when that was very controversial. They tell their story in this narrative of American success against the odds, which is interesting.
I do want to say something about Thomas to explain my rude behavior.
Because we are on...
I know.
Yeah.
What everybody remembers, of course, about Clarence Thomas is Anita Hill and all of that. And the HBO movie brought it back a few months ago. A lot of people don't know this, and this is a moment in American history that I find surreal and buried, and I don't know how it ever happened that way. He was asked. He graduated law school in 1972 or 3, around the time Roe versus Wade was decided. And he went to Yale Law School, and they had a career in government and other places. In 1980, when I went to law school in 1980, long before Lori did, you couldn't get past one day without Roe versus Wade being everything about in fact, I mean, Bork and Scalia were born in the wake of Roe versus Wade. I mean, everything about that is important. He was asked, does he have an opinion about Roe versus Wade? He predictably said no, and that's fine. And then I think it was Biden, I'm not positive, but I think it was Biden said to him, well, you will know, but he said, have you ever debated it? Have you ever argued it? Have you ever discussed it? And what was his answer?
He said he had not.
He said he had never discussed Roe versus Wade. Stop. Then you're incompetent or you're lying. Right? But the thing about my not as anywhere near extensive review of confirmation hearings as Lori's is if I had to critique them, it would be there's never a follow-up question. It is the lack of the meaningful, serious follow-up question. So how did we get a Supreme Court justice in 1992, who, by the way, changed American history because he replaced Thurgood Marshall, and without Justice Thomas replacing Thurgood Marshall, we don't have the gun case Heller, we don't have Citizens United, we don't have a lot of we don't have parents involved, the voting rights case. How does he get away with saying in the last 20 years, I have never once discussed Roe versus, debated is what he said, Roe versus Wade. Am I not accurate?
Yeah, they did follow up. And at some point, I think the senators need, and this is true of not just Clarence Thomas' nomination, but of all of the hearings, they need to make a decision about whether a non-answer is going to be a reason to vote no. And I think one of the things that's really interesting about the hearings is there are some cases where it would be. Brown, again, is my running example. Sure. A nominee who refused to give an opinion about Brown would not be confirmed. But not all cases are things that senators are willing to go to that extreme for.
But never having debated it, we should stop.
There's a lot of people with their hands up. Let's go back in the back over there.
I'm just curious about what you all think regarding educational background for the justices. If you look currently who's on the court, they all have very, very similar Harvard Law School, Yale Law School, and I don't know if that's always been the case or if that's more recently, and what do you think about that?
I think there used to be a bit more variety
Yeah.
in terms of the schools that the senators came from, or that the nominees came from. I think one of the reasons we're seeing that happen is it helps to make the nominee a little bit bulletproof, right? Because you want the very impressive resume so no one quibbles about formal qualifications. What I think is tragic is that we've lost people. With Justice O'Connor, we lost the last justice who had actually served in elected office.
It's actually much, much worse. It is true that Harvard and Yale accounts for all our current justices, with Justice Ginsburg going to Columbia for a couple of years. But it's much worse. There are no defense attorneys on the Supreme Court. There are no politicians on the Supreme Court. And even worse than all that, not only are they all Ivy League centered educationally, they are politically centered in Washington.
And they come off the D.C. circuit.
And they come off the D.C. circuit. They're the law professors or they're judges. Sotomayor was a prosecutor, but she too, despite her very diverse background, she came up through the same. And so, ironically, the irony is almost painful. Justice Scalia once said in a case, and if he lived by this adage, he would have been our greatest justice instead of one of our most pernicious justices. Justice Scalia once said in a case involving the right to die. It was a very big case about end-of-life issues. And he said the right thing. He said, we shouldn't be involved in this. This is not up to judges. The Constitution is silent. 9 people picked at random out of, I think it was Kansas City, out of the Kansas City phone book, have just as good opinions about this issue as we do. I think he's right about that. The problem is, he then for the next 25 years voted to strike down hundreds of laws that he didn't like. So I mean, but the sentiment there is correct. But if Scalia is right, and in fact it is all about that it's inevitably going to be about values, then we need to at least have diverse values, and we don't, not even.
The thing that those 9 people in the phone book haven't done, though, is they haven't gone through the confirmation process.
Say that again.
The thing that those 9 people in the phone book haven't done is they haven't gone through the confirmation process. They haven't had to sit in front of the senators, who, of course, represent us imperfectly, as any branch of government, any representative government will have gaps in the perfection of its representation. But everyone who sits on that court has to go through that process, has to avow under oath certain things that they say they believe and don't believe. That doesn't change the fact that they're making valued choices, but it does change the consequence of that fact, because it puts them into an environment where there is a checkpoint of sorts. Where we do have some control over the long-term judicial decision-making. Now, without term limits, that becomes much too disconnected. And when you see the court in crisis, it tends to be when the old guys are sticking around too long.
But it was, I mean, we promised not to debate each other, but.
Has anyone ever had a conversation?
But this process led to the United States of America having a Chief Justice of the Supreme Court of the United States who testified under oath twice that Supreme Court judges are umpires and should do nothing. Are umpires. And they don't make the rules. This is a quote. They don't make the rules. They enforce the rules. And at least a less accurate description of what Supreme Court judges do is not possible. So any process that allows that kind of person to get through with that, Judge Roberts, is deeply flawed, because that's a demonstrably false statement. They, in fact, make the rules.
Let's see. Let me do somebody back there. So, yes.
Given that fact, and that we have a constitution that's very big, written over 200 years ago, in a society that could possibly imagine, what other choice do we have in how the Supreme Court functions?
I wrote a book on that.
I mean,
That's okay, no.
in the tournament, okay, I can see that, but what else?
Yeah, we should, and I understand the fantasy nature of what I'm about to say. And Lori, this is where we may depart substantively, but yeah, I have an answer to you. We could do several structural things. We could say 7 of 9 have to agree before they strike down the law. That's one thing we could do. That would make it harder to do it, right? It would take a more bipartisan type of blending of liberal and conservative justices to strike down a law. I think that would work great at the federal level. Probably a state level too, but I'm not sure about that. Another thing we could do is say, and maybe we have to amend the Constitution to do this, you have to be sure. In times of stress, our country does do unconstitutional things that we all would agree are unconstitutional. But it's actually pretty rare. And Justice Oliver Wendell Holmes said, you really shouldn't strike down a law unless it makes you vomit. That's what he said. Vomit.
After he upheld the forced sterilization
Yeah, well,
and developmentally disabled girls.
He was on the bench for 50 years and made a couple bad decisions. But yes, we can make it harder for them to tell a unanimous Senate and a Republican president that they can't repass the voting rights bill, right? We could make it harder for them to do that. And I think that would be better for our country.
I think a little more judicial humility, which is what Eric is
Yes.
asking for here, would be a good thing. I think the aggression of the court, and by aggression I mean its willingness to affirmatively use its power to invalidate duly enacted legislation, ebbs and flows. We tend to hit high points when the political entities become less functional, and I think we're in one of those right now. So I agree that a little less hubris and a little more humility would be a great thing. That's tied to debunking the notion that this is all about umpires and activists. Because if the public discourse is that you're an umpire, then there's no need to be humble. Then you're just calling it as you see it. And changing the discourse is something that I think is critically important on 2 points. Both on the discourse of constitutional certainty, umpires, that if you're just smart enough and well-intentioned enough, you'll get to the right answer, and that's a single one thing. I think that discourse, that framing of what constitutional law is very destructive because it enables hubris. It doesn't humble it. The other part of the discourse that I think needs a little work, and I would like to see moved a bit, is the notion that the Supreme Court decides a thing and then we're done. There's lots of empirical data on this. And what happens much more often, with very few exceptions, most of them being First Amendment cases, the Supreme Court, it's an ebb and a flow. The Supreme Court makes a decision, it kind of sees if it sticks or not. If it's gotten out of whack with what people are willing to accept, the political branches push back, the court pushes back, and more often than not, we actually end up where long-term, not short-term, but long-term public opinion is centered on most issues. That doesn't mean that what the court does on a day-to-day basis is not important. Lots of people suffer lots of things when the court gets out ahead of itself or is too aggressive in its use of its power. But in one sense, it's not quite as consequential as we think of it as. It is a part of a political system and all of the checks and balances that come with it. It doesn't stand separate from it, and it never has.
Can you give an example of that?
An example of, yeah, go ahead.
In 1962 and 3, this is actually not a great example, but it's an interesting one. The court says you can't have prayer in elementary school. And that was, by the way, a woman at Richmond Law School has written a great article saying that's actually the most controversial Supreme Court decision of all time. If you do it by objective measurement of what happened next, more than Roe, more than Brown, and it was impeach or Warren, no, it was you can't have prayer in elementary schools. That was, there were 2 cases in 62 and 63.
Gender rights, sexual orientation rights. I mean, these have all been in little fits and starts. Before the Supreme Court decided Lawrence and the marriage equality case, it decided a horrible case I forget the name of it.
Ballots for Harper.
Ballots for Harper, exactly. And there was pushback, and there was a social movement, and there were boots on the ground, as someone in the play said, all of which have an impact on where the court ultimately goes.
So my point, but I want to say, I was in Alabama in the late 80s and early 90s. There was a lot of prayer in elementary school. I mean, the fact the court says no doesn't mean it's not going to happen. And the ACLU does not have the resources to go to every small town in America and stop it. And my point is, I agree totally with Laura's narrative about this. But it leads to a different conclusion, which is, I think if you look at history objectively, you will see, you can't do that, but if you look at history, you will see the court can stop progressive change. From 1903 to 1936, the court stopped a lot of progressive change.
And more often than not, that's what it does.
And that's what it does
when
more
the court
often.
used, I mean, the Warren Court was an anomaly in the history of how the U.S. Supreme Court has used its
When it
power
tries
over
to
time.
force progressive change, there are some exceptions, but when it tries to force it, and abortion is the best example. In 1969 in this country, rich women could get abortions in rural areas, and they still can, and poor women in rural areas could not, and that's still the case today. But there are other examples too. It took 10 years after Brown. 10 years after Brown, the South was 98.2% segregated. A decade later, Kennedy gets shot. LBJ gets the Civil Rights Bill passed. Federal government, Congress says you lose our money. If you still, that's what changed. Now, people disagree over whether that was possible without Brown. I think it comes faster without Brown. There are people who disagree with that. But the point is, it wasn't Brown. It was Congress that changed segregation. But they can stop it, and they have. Voting rights is one example.
So I'm going to take a couple more questions. Let's see, you've had it for a while.
What is a nominee's batting or a nominating president's batting average? About what chance does he have of getting a nominee through?
Historically, it's about 20% of nominees actually are competitive. I'm sorry, 20% are not. Of the ones that are not, some are withdrawn, and some of those are withdrawn because of an expectation that they won't succeed. Harriet Myers might be an example of that, but it's officially withdrawn, not rejected. But the number is historically about 20%. Interestingly, it used to be closer to 27%. We rejected more presidential Supreme Court nominees in the 1800s than we did in the 1900s. So all this discourse about how Bork changed the world and this used to be this little kumbaya process, it's really just nonsense.
Can I tell one quick story about that? Because it's a really, I'll make it 3 minutes, I hope. This is how important the confirmation process is and how political it has always been. And this is something I didn't know because we don't teach this case in school until I researched this for a separate reason. So the Constitution says that Congress can print coins, can have coins. It says nothing about paper money. There's not a syllable about paper money in our Constitution. And the first time Congress printed paper money was the Civil War to fight the Civil War. This was a huge issue. And the Civil War ends, and creditors hated the rich creditors, who were Democrats at the time, decided Congress doesn't have the power to do paper money. All they can do is coin. And the Republicans at the time disagreed. And creditors wanted no paper money. Debtors wanted to pay back in paper money because it was less expensive. Anyway, the Supreme Court strikes down Congress's power to issue paper money. Says it's unconstitutional. And they do it with an 8-person court, but one of the justices retired on that day. On that very day, not for that reason, he'd announced his retirement earlier. On that very day, President Grant names 2 people to take their places, because there's 2 vacancies there. And everyone in the country knew that Grant, a Republican, wanted to have a court that would affirm Congress's decision to issue paper money. So he names these 2 people. A year, and by the way, it's an 80-page opinion, which scholars later said was the argument that was most evolved at the Supreme Court to date in history. It was our entire economic system. I mean, it was. Does Congress have the power to take, to do money? A year to the day, the Supreme Court reverses itself, and all they did was flip the dissent with the majority because they had the votes. And in fact, the dissent said nothing has changed. Same facts, same history, same Constitution. All that has changed is the people on the court. And even the dissent even said, and the newspaper said, Grant, did this for one reason only, for this case. That's how important it is, A, who sits on the Supreme Court, B, how political it has always been, and C, what the confirmation process is really.
George Washington had a nominee rejected because they didn't like his position, the Senate didn't like his position on the peace treaty negotiated with England.
Is there a precedent to a nominee not getting a Senate vote?
Merrick Garland.
Repeat the question.
Merrick Garland was the answer.
The question is there precedent on a nominee not getting to the committee? Not quite, but it's a little more complicated than the soundbite. We didn't routinely have hearings. Hearings were not normalized until 1955. So whatever tradition we have of giving nominees hearings started sporadically in 39, and then in 1955 became something every nominee did. Since 1955, we have not had a nominee who was not either withdrawn or given hearings. We had several who were rejected, and we had several more who were withdrawn because of the anticipation that they would not be given an affirmative vote. But even Robert Bork, interestingly, to come back to our topic of the night, Robert Bork knew coming out of the Senate Judiciary Committee that he was going to fail in the Senate. He got a negative vote coming out of the Senate Judiciary Committee. Everyone knew the vote count in the full Senate, and he knew that he would not be confirmed, and the Reagan administration knew that he would not be confirmed. And Judge Bork made a very emotional public appeal. And what he said was, I am not going to resign. I'm not going to withdraw my nomination. I'm not going to ask the president to withdraw my nomination because this process won't work if the Senate doesn't have to vote. So they made him vote, and he forced it. He forced the Senate to a vote by not withdrawing. The Senate voted, and the political chips fell where they did.
By the way, he was weird. Sorry, go ahead.
Okay, so in April there was an article written, it was an opinion in the Washington Post that said that because the Constitution only says that the Senate has the, you know what article I'm talking about?
Yes, but someone just, yes.
Okay, so what are your thoughts on that?
Quick, someone wrote an
because of
article
that.
saying that the Senate could waive its right to object to a confirmation if they don't act on it.
And that Obama could assume that they
Yes.
are waiving the right to object if they do not take a hearing
I was
after
actually asked
125
to
days.
work on that project.
Yeah.
I didn't, even though I'm a liberal Democrat, because it's a really, really stupid idea. And no, the Senate cannot waive its right to object. There's no constitutional requirement to have a hearing, and the proof of that is what Lori just said. We didn't have hearings until 1939.
The best argument, and I'm with Eric, I don't think this ultimately carries the day, but the best argument to support the position, I think, that the Senate is somehow acting unconstitutionally in its inaction, would be a separation of powers argument. There is a separation of powers principle that says that one branch can't use its power to completely nullify the powers of the other branch. So, for example, Congress, as we all know, has the power of the purse. But if Congress was to use that power to completely defund the executive and say we are not going to actually allocate any money at all for an executive to exist, you'd probably have an unconstitutional separation of powers problem. I don't think this rises to that level.
Well, first of all,
because the obligation is shared.
And Congress can change the number to 8, 7, 6, or 15 tomorrow. It's not in the Constitution. I would point out, for those who care about history, which nobody really does, but if you did care about history, and the Supreme Court, I mean, in 1801, a very politicized case involving not Supreme Court judges, but lower court judges, was going to the Supreme Court, and Congress turned the candles off at the court for a year. Literally. Congress said to the Supreme Court, you may not meet for 10 months or 11 months and 2 terms. Now, I have to say that wouldn't be constitutional today, but
It was all about the Federalists, as they were lame ducks. They had all run and the new kids were coming to town. And Congress enacted legislation giving the outgoing Federalist President, John Adams, 1 billion lower federal court judge seats to fill. And then he failed to actually deliver the commission on it, and thus we had Marbury v. Madison.
So do we have a right to bear arms?
no. No, emphatically no. Not from the Second Amendment. You do from 43 state constitutions. In other words, 43, I think it's 43, it might be 42. States have state provisions protecting your right to bear arms. And from state law, those constitutional provisions give you the right to bear arms.
I have a prediction on this one. I think the individualization of the Second Amendment, the thing that Heller decided that said this is a personal right, not a regulated militia right, I actually think that the core of that decision will become part of our accepted constitutional norm. just the core, the piece of it that says this is actually an individualized right. Now, that doesn't mean anything in terms of what it means for regulations, what it means for constitutionality of reasonable regulations, what it means for the so-called standard of review, meaning the extent to which the court will review laws that restrict the rights. All of our rights, things that are constitutional rights, are still restricted in an abundance of ways. But I think that core nugget, because, and this is why I think it, and it comes back to my theory about what the confirmation process is about. Americans believe that they have that right, and they believed it long before Heller was decided. Something like 80% of the American public have believed for literally decades that there is a constitutional right of some sort to bear arms. But the of some sort is the really important piece there.
I think Lori is right, but I will say that could change with a few more disasters.
Yes, that's possible.
And the other thing is,
Or some really stupid decisions about what reasonable
yeah,
regulations.
absolutely. Justice Scalia took Justice Kagan hunting in Mississippi or something. There's something very symbolic about that. No, I'm serious about this. I think that Justice Kagan actually believes. The 4 dissenters in Heller at the time did not. So there were 4 judges at Heller who said, this is crazy, it's not a Second Amendment right. I actually think Justice Kagan might be sympathetic.
And she actually said that.
And,
this is one of the things
yeah.
at her hearing,
Yeah.
Both her and Sotomayor at their hearings said that they accepted, which is kind of code word for, I'm going to be a little pudgy on this, but that they accepted the precedent that said that there was some basic individual right to bear arms, but they were not going to comment on what that meant in terms of reasonable.
But I'm with Justice Warren Berger from Minnesota, a very conservative Republican, who said, and he was exactly accurate, that the idea that the Second Amendment contains an individual right to is not just wrong, it's not just careless, it's a fraud. Berger called it a fraud, and he's right.
So what does that amendment mean?
It means that the founding fathers, we know exactly what it means. That's the
Okay.
irony of all this. Read non-lawyer historians and you will find out. The founding fathers were deathly afraid of standing armies. They were deathly afraid of them, coming from the King of England. And they were very afraid of our new national government that might be tyrannical. And they wanted a stopgap. What happens if this new national government decides to be tyrannical over Georgia or Pennsylvania? Well, they had every able-bodied man over 18 for a certain age had to be part of a well-regulated militia, and that was their absolute security blanket. That we need to have these muskets in these people's arms in case the federal government becomes tyrannical. There were regulations in Boston and Philadelphia about where you could take guns, how you could take them, in bars, saloons, public places. It was never about hunting or self-defense.
But of course, the whole history of progressive constitutionalism is a story of that things change, right? Progressive constitutionalists do not consider themselves bound by original intent specifically interpreted.
But the Heller majority are not progressive constitutionalists, as
I'm
they
not,
said they
but
were.
I understand, but you can't have it both ways, right?
Interestingly, and Eric, I first saw you on a panel at the Georgia Bar Association debating this, and you were very passionate. When Governor Deal made the good decision to veto campus carry, he evoked Scalia in the Heller decision saying it's not unlimited. And he did the right thing, but you have to know how and I know that Monroe was on that, John Monroe was on that panel. I don't know if any of the other politicians that are the ones who brought this up, but they had their committee hearings in secrecy. They tacked, and there were 2 bills. There was the campus carry bill, and there was what we call the guns everywhere else bill. I got word of them tacking on campus carry in their committee from my state rep. I was napping because I'm retired, and he texts me and he says Jaspers has his campus carry piece all ready to go. It's going to be this afternoon. Tune in. Exactly a week later, they did the same thing, but I happened to be down at the Capitol, and I had 3 hours to grab the bill, the 1060, and prepare what was really the only testimony against it. and Deal vetoed that one too. So he finally did the right thing. I think he was just pissed off at them.
The danger that I see that I think Lori underestimates in calling it a constitutional right is now we start talking about speech and religion and why is it
Yeah.
second? And then it gets harder to recognize and remember the first few words, a well-regulated, right? We don't say well-regulated speech. We know that that's not true. We have to have a lot of speech, right? For democracy to flourish, there has to be a tremendous amount of speech. There doesn't have to be guns at all, much less, a lot of
Yeah.
This has been a fantastic session. I know they'll hang out for a couple minutes. I don't want to take too much more time. You've been a fantastic audience. We thank you for your participation, and feel free to come down and ask questions.